the Catholic University of America Columbus School of Law, and I'm happy to welcome you to this program on criminal law reform, ethical and legal changes in Austrian society. This slide is a misnomer, so just ignore it. If someone could fix it, it'd be great, but if not. This program is sponsored by the Comparative and International Law Institute, and we're delighted that Greg Watson is here, and also the Interdisciplinary Program on Law and Religion. And my colleague Bob Destro is on sabbatical, and also he had to take his wife to the doctor, so we're excusing him on both counts. But our program today is very interesting, and I think important in light of the debates that have taken place here in the United States on penal law reform, one of the only issues where the right and left, far right and far left, can get together, and hate speech, which is on the front burner given the present situation related to terrorism, both in the US and in Europe. And I think it's important for us to see how other societies are approaching these problems. We are also, I should say, honored by the presence of Ambassador Walder, the new Austrian ambassador to the United States. Will you stand for a moment? He arrived 2 weeks ago, so this is one of the first places he's visited, so we have to really treat him nicely so we can get him to come back. Our speakers today are the Honorable Wolfgang Brandstetter, the Minister of Justice for the Republic of Austria. He was a law professor, and there's nothing more to say, really, and also a defense lawyer before that. He has visited us before, and I think we may have to make this a permanent lecture, the Republic of Austria lecture, every year, because we get such a wonderful turnout and such an excellent talks. And our second speaker is Dr. Christian Pilnacek. Actually, he will be our first speaker, Dr. Christian Pilnacek, Director General for Criminal Matters in the Austrian Ministry of Justice. He is an expert on Austrian criminal law and has served as an advisor in the district court and other courts. He will speak on hate speech legislation in Austria, and Dr. Brandstetter will speak on penal law reform, correctional law reform in Austria. And I think we will start because we want to have time for questions for the reception that we have afterwards. And I should just remind the students that this lecture will receive ethics credit, so you should sign the sheet outside to make sure that you get your credit. So without further ado, I invite Dr. Pilnacek to take the podium.
So it's a great pleasure. Thank you for the invitation to speak in front of you. And it's perhaps for me not so easy to start in front of my minister and all the distinguished guests. And you should know, it was mentioned, my minister is professor in law, for criminal law. And you can imagine each conversation and discussion about law topics reminds me to my exams at the University at Vienna that 30 years ago. Lucky, I never had an exam with him. But now, you understand, I stay in this inconvenient situation. But let me say, bearing in mind, once the First Amendment, and second, also the beginning of the Holy Year dedicated to mercy. I hope you will show mercy to my speech. I could not finish in a well-prepared manner, but I will try to explain something about the Austrian situation. So the wind reap the whirlwind. Hosea 8-7. Every decision has consequences. A person's action will come back to them. Perhaps this parable of the Old Testament could serve as a starting point for our discussion. First of all, I will give you a short explanation about our prosecution's office and the system of our prosecution offices in Austria.
Is the microphone on?
It's better now.
Okay, thank you.
Public prosecution offices are special bodies separate from the courts, safeguarding the public interests in the administrations of criminal justice. This primarily involves bringing in charges against persons and raising and representing indictment in criminal proceedings. Public prosecution offices are judicial authorities, but in contrast to the courts, they are not independent. They have a hierarchical structure and are bound by instructions of senior public prosecution offices and ultimately of the Federal Minister of Justice. There are precise statutory rules for the right to issue instructions. Instructions by a senior public prosecution office or by the Federal Minister of Justice may only be issued in written form and must contain a statement of reasons. Moreover, any instructions received has to be recorded in the criminal case file, so it is open for the defense counsel as well for the victims. The Federal Minister of Justice bears ministerial responsibility and is thus accountable and obliged to provide information to the Parliament. The 2016, an independent advisory body was set up with the aim to examine the merits and reasons of the planned instructions to the senior public prosecution officers. One feature of the Austrian public prosecution services, we have perhaps 400 prosecutors dealing with criminal proceedings in Austria, 17 prosecution services, 4 higher prosecution services, and my unit is dealing with the preparation of written instructions if there is needed for a proper administration of justice. Perhaps to give you a short overview, and for you it might be of interest how the differences can be between the First Amendment of your Constitution and our constitutional law. Article 1 of the Federal Constitutional Law on the implementation of the International Convention on the Elimination of all forms of racial discriminations defines racial discrimination as any distinction on the sole ground of race, color, descent, or national or ethnic origin. According to well-established case law of the Austrian Constitutional Court, any differentiation among foreign nationals by the legislature and the administrative authorities is prohibited due to this federal constitutional law unless the differentiation is based on an objective justification. Article 14 of the European Convention on Human Rights, which is important for Austria, which has the legal status of constitutional law, prohibits discrimination on any ground, such as, among others, race, color, religion, national or social origin, association with a national minority. Finally, the rights enshrined in the Charter of Fundamental Rights of the European Union, and thus the comprehensive prohibition of discrimination according to Article 21 of the Charter, can be claimed as constitutional guaranteed rights in proceedings before the Austrian Constitutional Court whenever the Charter is applicable. To the Austrian policy in this field, the promotion and protection of human rights and fundamental freedoms on national level as well as internationally plays an important role for the Austrian government. There is a clear understanding that special attention must be given to the fight against racism, xenophobia, anti-Semitism, and related intolerance, and Austria remains fully committed in this fight. In Austria, good legal tools exist which enable authorities and courts to combat right-wing extremist, xenophobic, anti-Semitic, and racist acts. However, the federal government is aware of the fact that racist prejudices, attitudes, and acts still exist and are happening, and that sustainable and differentiated policies are necessary in order to counteract this phenomenon in the long term. Austria strives to continuously improve the protection system through legal provisions and their implementation as well, equally important through awareness-raising measures and education. This is an ongoing process based on a firm commitment, openness, understanding, and dialogue. Criminal law. The most important provision is Section 283. This section deals in its para 1 with the public incitement to violence against groups of people or individuals because of their belonging to such group. The groups which are protected by Section 283 are groups which are defined on the grounds of race, color, language, religion, nationality, descent, gender, disabilities, age, or sexual orientation.
Excuse me, what does public incitement mean?
Public incitement is a speech with the aim to create violence against the group or members of the group. So the inclusion of the wording "or incites to hatred against them" in this provision, the incitement to hatred not only against groups but also against a specific person belonging to such a group, is becoming now a punishable offense. Thus, this provision now comprises the prohibition of incitement to hatred against groups and individuals as well as of incitement to violence against groups and individuals. So the inclusion of another qualification for a group in Article 283, namely the existing or non-existing of nationality, incitement to hatred or violence against foreigners or non-Austrians, also became a punishable offense. Change in the criteria for public statements or comments inciting people to violence or hatred will become punishable offenses if they are made in public in a manner that is accessible to many people. The term "in public" refers as a rule to approximately 10 and the term "many people" to around 30 individuals. If such acts are accessible to the general public, perhaps 150 individuals, so distribution in print or other media, they will be punishable with a maximum of 3 years of imprisonment. Article 283 of the Criminal Code provides for the prosecution of hate speech irrespective of the medium through which it is communicated. Accordingly, racist content publicized on the internet is covered by this provision if it exceeds a certain threshold as mentioned above. The Association of Austrian Internet Providers has set up a virtual contact point, Stopline.at, for all Internet users who happen to come across, for instance, any neo-Nazi or racist content. Once the content has been identified and verified as illegal, the respective provider, foreign partner hotlines, and competent authorities are promptly informed to enable them to take necessary action. Stopline cooperates in this context with the Austrian Federal Ministry of Interior as well as with its relevant reporting offices. Today we had a discussion with Facebook how we can proceed in the deletion and stop of hate speech about this social media. Anyone who his or her own actions or deeds causes other persons to exercise violence against a protected group or against a member of any such group as a consequence of his or her affiliation with this group will face a prison sentence of between 6 months and 5 years. The establishment of or participation in associations whose purpose is that of incitements within the meaning of this provision, fomented by their members, became also a punishable offense. Racist threats and verbal abuses that are made with the intention to violate human dignity of the persons in public are criminal offenses. The criminalization of racist threats has been improved through lowering the threshold for public also in this context, taking into account that the state has an obligation to find a right balance between the right of freedom of expression and fighting racism and racist discrimination. Only those verbal abuses and slander against one of the groups or persons mentioned in this provision that intend to violate human dignity are to be criminally liable. There exists clear case law about the definition of violation of human dignity by the Supreme Court, which is to be followed by the courts. This limitation, set deliberately by the legislator, does, however, not impede sanctioning of racist and discriminatory threats and abuses outside the criminal law, like the Civil Equal Treatment Act or the Administrative Penal Law. In addition, Section 115 of the Criminal Code offers another criminal liability for the act of general slander or mockery that can also be based on discriminatory remarks. Through the inclusion of a new Section 3 of the provision of 283, the public denial, trivialization, justification, or condoning with a racist aim of genocide, crimes against humanity, and war crimes is now a criminal offense and can lead to imprisonment of up to 2 years. Following other international recommendations, like the EU Framework Decision and new Article 283, subparagraph 4 was included, making the public dissemination or distribution of material containing racist manifestations also a criminal offense. Explicit intent for incitement to hatred is not a necessary precondition for criminal liability in this case. Concerning the criminalization of the participation in a criminal organization, the new criminal law makes a reference to this provision through which also the foundation of and/or participation in organizations or groups that incite to racism, racial hatred, or racial discrimination is a criminal offense. The aggravating factors for punishable offenses committed for particularly reprehensible motives in Article 33 have been extended to include offenses directed against a church or religious society or another group defined by criteria of race, skin color, language, religion or belief, nationality, origin, or national or ethnic background, gender, disability, age, or sexual orientation, or against a member of any such group. Furthermore, next to the Austrian Criminal Code, other laws provide for a prohibition of discrimination, like the Equal Treatment Act in civil law or the Administrative Penal Law. As an example of the latter, Article 3 provides in its first part for a general prohibition of discrimination based on race, skin color, nationality or ethnic origin, religious denomination or disability in the exercise of one's occupation. The second part of this article punishes the denying of access to public places and services. One of the examples which lead us to strengthen our criminal law, on the 24th July, around 20 young persons attacked the football players of Maccabi Haifa during a friendly game with OSC Lille in Bischofshofen, a town in Austria. The perpetrators waved Turkish and Palestinian flags. A knife and stones were used. Of course, leading politicians condemned this anti-Semitic attack, and the criminal proceedings resulted in a 5 months suspended prison sentence. Now it would be possible to sentence this offense with 6 months up to 5 years. Figures about the proceedings. We have an increasing number of proceedings. You see in the first line from 2012 to 2015, increasing number of preliminary proceedings from 170s to 181 proceedings. We have indictment 2014 72, 2015 65. We have stay of proceedings 2014 166, 2015 176. Out of court settlements 2014 8 and 2015 also 8. Conviction 2014 31, 2015 34, and acquittals 2014 6 and 2015 9. Coming up to the terrorist association in the section 278B of the criminal code. It reads: a person who leads a terrorist association is to be sentenced to imprisonment from 5 to 15 years. A person who leads a terrorist association which confines itself to terrorist offenses is to be sentenced to imprisonment from 1 year to 10 years. A person who participates in a terrorist association as a member is to be sentenced to imprisonment from 1 year to 10 years. And the definition: a terrorist association is a union planned for a longer time of more than 2 persons aiming the commitment of 1 or more terrorist criminal offenses or financing of terrorism by 1 or more members of the association. The most relevant legislative provision related to the phenomenon of so-called foreign terrorist fighter, because not only the participation in combat operations, but also leaving to join them can be qualified. That is a mistake in writing in this page. Terrorist criminal offenses are in least murder, bodily injuries under sections 84 to 87, extortionate, kidnapping, gross intimidation, dangerous threat, gross damage to property, and damaging of data if there be a danger to the life of another person or a danger to the property of another person to a large extent can be caused. Intentional offenses of dangerousness to public safety or intentional infringement of environment, hijacking, intentional danger to safety of aviation. A person who commits a criminal offense under para 1 shall be punished pursuant to the law applicable to the offense mentioned there, and the maximum penalty is to be increased by half of the penalty being prescribed respectively, but not exceeding 20 years. In 2016, the 1st of February, 39 persons are detained because of the suspicion of terrorist offenses in Austrian jails. We have had 2015 179 preliminary proceedings and 50 indictments. You can here also see the increasing number caused by the phenomenon of terrorist foreign fighters. A successful integration has two sides and also concerns the so-called receiving society. Austria is therefore constantly taking measures at several levels to combat racial discrimination, xenophobia, and related intolerance. We cannot overlook the fact that social tensions, prejudices, and sentiments against migrants and asylum seekers are on the rise. Europa will fail if its citizens live in fear. Fear is fueled by ignorance and opens a wide door of violence. Hate speech, which incites to violence and hatred, particularly online, is increasingly worrying and now constitutes the main source of hate incidents. Importance of cooperation with IT companies and the media to combat manifestly illegal hate speech and promote counter-narratives emanating from civil society. Tackling hate speech online, development of specific frameworks or guidelines for law enforcement or judicial authorities, setting up of special law enforcement or prosecution units, setting up of special platforms for monitoring and recording, providing financial support to non-state actors, promising case law and strengthened cooperation between national authorities and/or cooperation with non-state actors such as civil society organizations. Of course, specific training programs for prosecutors and judges are needed. And in schools and education sector and in the public, awareness rising is needed. So perhaps in closing my remarks about the legislation on hate speech and terrorist organizations, we can discuss the topic in addition after the speech of my minister, or as you promote.
We thank you. To save time, I'm not going to get up, and I'll just ask the Honorable Wolfgang Brandstetter to address us. Thank you.
So my dear colleagues, ladies and gentlemen, first of all, I have to thank Mr. Pilacek, who is in charge of the probably most important unit in my ministry, because he did what he always does in my ministry too. He gave us the necessary information about the legal basis.
Can you speak a little louder?
Yes, and We'll see, it's good that we will have a discussion together because there will be questions you will ask me, and I probably will have to ask Mr. Pilnacek because he knows everything in his mind. So I'm really happy to be here. And, Mr. Pilnacek already has pointed out what we are doing against hate speech and hate crime in Austria. In fact, we just recently sharpened our laws against this phenomenon. And I personally am sure that quite often there is a relationship between hate crime and radicalization. We have too much hatred visible on the internet and within society as a whole. Moreover, there is far too much violence on the streets. These phenomena are, to a certain extent, connected. And as my colleague, Mr. Pilnacek, already pointed out, hate crime is rising everywhere. And just recently, on Friday, we were in Los Angeles and visited a big jailhouse, and we had very interesting talks and discussions with high officials being responsible for the jail system in Los Angeles. And they told me the same. I got the 2014 hate crime report from the Los Angeles County Commission on Human Relations, and there too, they have a rise of this sort of crime. So, especially in Austria, the phenomenon of the so-called foreign fighters or jihadists we are confronted with in Europe now has undoubtedly quite a lot to do with blind hatred and the incredible radicalization of especially young people, both male and female, most of them being misled by fanatical religious ideas, normally radical Islamic thoughts. Often they are misused by questionable imams, but in reality, often enough, they are just youngsters searching for their personal way of life and getting a kick out of being rebels. Sometimes rebels without a cause, just like James Dean in the famous movie of the same name. One of the characters in this movie, as you know, the older one knows about that movie, but one of the characters in this movie loses his life in a totally senseless way. And this is true for foreign fighters too. We had more than 250, or maybe even more, Christian, more than 250 foreign fighters coming from Austria. Many of them have Chechen roots. And it is interesting to note that when President Putin started Russia's military action in Syria, supporting President Assad, a number of foreign fighters with Chechen roots who had applied for and received asylum in Austria a few years before went or wanted to go to Syria to fight against Putin there. So this shows that these foreign fighters are not only motivated by religious reasons. It's somehow crazy what they are doing. Well, up to now we have caught about 39 foreign fighters who returned to Austria after having supported terrorist activities or who planned and prepared such activities in Austria, and they are in prison, 39 now. Some of them were already sentenced up to 6 years of imprisonment, and in these cases, the question of de-radicalization in prison is raised and needs to be carefully examined. In order to be prepared for the challenges arising therefrom, a task force, de-radicalization in correctional services, was established in Austria to prepare and efficiently implement the necessary prevention, de-radicalization, training and cooperation measures, which includes management personnel from the Directorate General for the Administration of Custodial Sentences and Measures involving deprivation of liberty in the Federal Ministry of Justice. Among them, this is very important, a criminologist, a forensic psychiatrist, and a certified psychologist, a social worker, and the head of the Correctional Services Academy. And as you know, we even got support from one of your colleagues. Therefore, the task force consists of 13 executives from the Correctional Services Administration who several times a year hold a jour fixe and of an expanded body with external experts. Furthermore, an executive team coordinates and monitors activities in this area, prepares strategies and proposals for implementation, and organizes current exchange of information among members. So let's go to the basis again. The law regulating our prison system is based on the European Convention on Human Rights, which has the status of constitutional law in Austria. Correctional services are a federal matter, both with regard to legislation and enforcement. The management of correctional services rests within the responsibility of the Federal Ministry of Justice as a supreme penitentiary authority. There, the Directorate General for the Administration of Custodial Sentences and Measures of involving deprivation of liberty has been established to perform strategic and operational management and for exercising responsibilities as an authority for service and professional supervision. There are 27 prisons in Austria, 15 thereof for pre-trial and penal detention, the rest for penal detention and measures involving deprivation of liberty. 144 of any 100,000 people are presently held in prison on an average. In Austria, this number is slightly below 100. So 144 is the international average number. The whole number of the prison properties is about 9,000 now, and we have to use our full capacities now, and therefore are planning new and modern facilities. And that offers us more chances for education and work. And this is very important because, as a matter of principle, all detainees who are fit for work are obliged to work in prison. Excluded are jobs that may lead to mortal danger or bear serious health hazards. Employment in meaningful and useful work has proven to be valuable to make longer imprisonment bearable. Furthermore, detainees can acquire skills which would facilitate building a well-ordered livelihood after release from prison. Altogether, work is an important element in the correctional services system. From the point of view of detainees, work is an essential factor for establishing social contacts in prison and at the same time the only chance for detainees to earn some money during detention. A further important aspect of work in prison is for detainees to maintain or improve vocational qualifications and provide them with meaningful occupation. Work is a defining precondition for being able to influence detainees in a positive manner and an important factor for their resocialization. This is what our law says. And recently, we had an amazing or amusing discussion because of the attempt by a number of prisoners to found a trade union. They wanted to have a union in order to improve the circumstances of the work and life in prison. I'm not kidding. They were not satisfied with their work-life balance and wanted higher salaries. Well, the attempt failed, of course, because all prisoners, as I already pointed out, are obliged to work in prison by law. But according to the European Convention on Human Rights, they of course cannot be forced to work, since this could lead to violence and torture in the last consequence, which is strictly forbidden. And I have to add that Prisoners who work, they get a small salary, which they can only partially use for personal needs. A part of the salary, which is below the market rate, is kept back until the day of release to make the new start after prison easier for them. I'm convinced that the basis of success is keeping the inmates busy, according to an old saying of the officials working in our prisons and correctional services. And this old saying is true. If we do not keep them busy, they will keep us busy. And that's why we will force the possibility of electronic monitoring as a sensible alternative to imprisonment too, because this form of correctional service is widely used and recognized on an international level. In specific cases and under restricted conditions, it aims at holding detainees in detention without tearing them away from their social environment and preventing them losing their jobs. Key to monitoring is a supervision profile which should ensure an orderly daily routine and yet must provide, in addition to hours on the job, adequate time for leaving the monitored area for the purpose of requirements of a medical, social, or therapeutic nature. But in this framework, also time for taking care of children, buying articles of everyday life, and other social activities, such as attending mass, can be accommodated without the objective of detention. Electronically monitored home detention can be ordered for any type of crime, but an individual assessment of the preconditions and in particular of the risk is required. And basically, home detention can only be used for detainees whose release is to be expected in maximum 1 year and who are not likely to abuse this form of correctional service. Persons convicted for a sexual offense can only serve the rest of the sentence in the form of home detention if they have already served half of the sentence, or at least 3 months. Furthermore, and this is very important, any approval of electronically monitored home detention is contingent upon offenders having suitable accommodation and a suitable job in Austria, earning an income for their life, and on them being covered by health and accident insurance. Moreover, persons living in the same household must give the written consent. And our legal reforms we are thinking about now, right now, will make electronic monitoring applicable for more detainees and prisoners. And the main reason for that is not the purpose to spare costs and reduce capacities, but to force employment and work, which is the key for a better life without committing crimes again. And if we should have the effect that the capacities in our prisons don't have to operate on 100% or sometimes even more, this would be great, of course, too. Well, you have to know that our whole jail system suffered a lot from the refugee crisis last year. You have to know that we had a peak of almost 600 smugglers in jail, 600 smugglers within a very short time period, when they tried to take refugees illegally from Turkey to Austria. And 600 is a big number in relationship to our normal capacity of up to 9,000 inmates. And it was not easy to master this difficult situation. So you see, and I come to the end now, you see that the overwhelming refugee crisis in Europe affects our jail system and our legal system too. And you should know that no country in the European Union is hosting more refugees in relation to its population than Austria now. And it is not by chance that Angela Merkel, Chancellor of Germany, invited the refugees to come very shortly after 71 dead refugees were found in a truck in Austria next to the Hungarian border. They were victims of criminal smugglers that locked them up without taking care of food, water, and air. These criminals were captured and will have their procedure in Hungary because the refugees had already died there. They all were shocked being faced with this horrible crime, and I suppose Angela Merkel was shocked too. Critics say that she was driven more by ethics than by political responsibility, according to the distinction made by the famous sociologist Max Weber. Well, I only want to say, my dear colleagues, ladies and gentlemen, I'd just like to take this chance to talk to you as opinion leaders, to draw your attention to a very smart article I read just last week in the International New York Times when we had our flight to the United States. This article has been written by Thomas Friedman, and allow me just to quote a few sentences. Thomas Friedman said, I saw it by chance in the airplane, the meltdowns of Syria, Somalia, Eritrea, Mali, Chad and Yemen, and our takedowns of Libya, Iraq and Afghanistan without proper follow-up on our part, NATO's part, or by local elites, has uncorked the worst refugee crisis since World War II. This tidal wave of migrants and refugees is a human tragedy, and the outflow from Syria and Libya in particular is destabilizing all the neighboring islands of the Red Sea: Tunisia, Jordan, Lebanon, Kurdistan, and Turkey. And now it is eating away at the fabric of the European Union as well. Why should Americans care? Because the European Union is the United States of Europe, the world's other great center of democracy and economic opportunity. It has its military shortcomings, but with its wealth and liberal values, the European Union has become America's primary partner in addressing climate change, managing Iran and Russia, and containing disorder in the Middle East and Africa. This partnership amplifies American power, and if the European Union is hobbled or fractured, America will have to do so many more things around the world with much less help. And, as he says, a tidal wave of people threatens to overwhelm America's top ally, the European Union. So, let me end by saying, sometimes we are lucky and find the best time and the best place to remember that we share the same values and ethics. And that's why I'm so happy to be here today at your famous university, addressing you as friends and allies. Thank you for your patience.
Thank you very much. We have time for some questions from the students or faculty, so please, and just direct them to who you want to ask. No questions yet? I will start. When you are dealing with intent to incite, you look at the feelings of the so-called victim, or do you make look at a kind of reasonable assessment of the intent of the person making the hate speech? I ask that because in some of the regulations related to sexual harassment in the colleges in the United States, if a person feels victimized, that is harassment, whether or not the person intended to harass, or whether or not the person, in some cases, even intended to focus on a particular individual as opposed to a general comment. So I'd be interested in that. How you deal with the question of the victim, either the group or the individual who says, my human dignity has been injured, but that may be a subjective view.
It's not, it's don't have a decisive role, the feelings of the victims, and if they are, if they felt themselves victimized, it's needed that the perpetrator is intended to discriminate by and to force to violence by his speech.
And also, you have to forgive me, I come from a very strong belief in the First Amendment in the United States. So I'm trying to understand these efforts to regulate speech. Is discrimination the same as violence? I mean, incitement to violence, we all agree, in America and in Europe, can be a penal act, a criminal act. Statements which propose discrimination or propose some negative feature of a group without saying, well, we should have violence. How are they also amenable to prosecution?
No, not itself. It must be. It must be as a consequence it might lead to violence. That must the direction of intent.
It's exactly what Mr. Bilacek pointed out, the point where hate speech causes violence, or typically causes violence. And this is the point we want to fight against with these sharp laws. But well, I know we talked about that last year, as you remember. We have laws, especially our laws against anti-Semitism. They have historical reasons, and probably they would be partially in conflict with the First Amendment. That's true, but nevertheless, according to our value system, our legal system, being based by the European Convention of Human Rights, which is constitutional law in Austria, as Mr. Bilacek pointed out, there's no alternative. And we really want to fight against hate speech with criminal matters, because I think it's really necessary. And sometimes I ask myself, where does all the hatred come from? I mean, it's rising, and it has its certain reasons, and there's always a certain object that is involved in this raising hatred. And I think we have to face the fact that these reasons have to be discovered and fought as well as possible. I mean, we are confronted with this phenomenon, and well, I think, of course, is a lack of freedom in some areas of the world that always causes more and more hatred everywhere. This is the root of the problem, I think.
This is the first time I've seen shy Catholic law students. Yes, sir.
I'm a student in the School of Canon Law, so I study ecclesiastical law, not civil law, so my question might be from a slightly different angle. Dr. Pilnacek mentioned that the criminal code holds people criminally liable for hate speech against a church or religious society. I'm wondering if you could give an example of something that rose to the level of being being a criminally liable statement against a church or religious society. Either an example or maybe.
In fact, the most offenses occurred these years was anti-Muslims threats. So against the Muslim community, perhaps as an force answer to our crisis of migration and asylum seekers. And perhaps you read in the newspapers some stories about the night, the New Year night, and in Colonia. And this also influences in hatred speech against members of the church and members of Muslims.
Okay, Pam?
I think it was in the first slide that you had presented on, and it was talking about the prohibiting racially related discrimination. I think the last phrase, I don't know if it was just boilerplate language, was unless objective justification. And I just wanted a little bit more clarification of what an objective justification would be. If it's that the person would have to prove that it was their acts were for reasons other than race and discrimination, or?
An excellent question, and I must think over if there's a possibility of this sentence. Perhaps we have in our media there's some quiz contest, and then we can ask our advisors and our professors. So perhaps you will.
This is your one telephone call.
Usually I have to ask him. But it's really a very good question, and I only can say that we really try to hit the point where hate speech becomes sort of violence. I mean, it's not easy to get this point, but to be honest, I was very astonished when I read in our mass media, I hope it was right what they told us, that Mr. Trump planned to let all the Islamic people outside of the United States, so they shouldn't be allowed to enter the country. Well, if this was right, what he said, I don't know it. But of course we were astonished, because, well, according to our value system, we would have problems with that. I mean, I can't say that everyone who is Islamic therefore is suspicious. It's ridiculous, of course. But I don't want to criticize anyone in the United States, not even Mr. Trump.
Any other questions? Yes, sir?
Can speech that's relating to race, can it be could you prosecute it if it was made sort of by implication? So, for example, saying something like Austria is a Caucasian nation, and then violence occurs after that. You didn't say that, it doesn't belong to group X or group Y, but there is certainly the implication. Would that be enough, or would it need to be a direct statement that this group is better than this group?
Basically, this would be enough. Maybe you would give a better answer. I mean, it would be enough to say, well, this is typical, this is a man coming from abroad, he's not Austrian, therefore he must be criminal. This should be enough, no?
Would it depend on the group that he's speaking to? That is to say, if he's speaking to a society of demography, as opposed to a group of people who are antagonistic to foreigners.
No, it depends on the number of persons who can hear
able
or
to-
take notice of what he's saying.
Well, this is a big problem, because it's the Society of Demographers may have a lot, 100, 200, 500 people, and it may be a scientific speech where that statement is well, it's a statement of fact, and it's not intended to lead to violence. It's simply
If it's not intended, then the provision is not.
even though like it did lead to violence. Someone speaks in the Society of Demography,
But this,
and
this,
then
this
a
could be an answer to the question of the young lady, the young student. Your example. That this is a justification to.
The basic question is, I mean, can a speech that is criminalized by law, can it ever be scientific? I doubt that. I don't think that. A scientific sentence or a scientific opinion should never be in danger of being criminalized, as we understand that.
we'll take one more question. Sir,
You mentioned that in Austria, if you don't keep the prisoners busy, they'll keep the
Yes.
officials busy. And then you also mentioned that you had visited a prison in Los Angeles. And I'm just curious to know, like, after being there and with taking your own prison system into account, do you see real benefits from keeping the prisoners in terms of like deterrent and repeat crimes?
Well, I don't think that there is any country in the world that has no problems with the jail system, with the detainee system. Don't think so. Maybe except Liechtenstein, or because they send over the detainees to Austria to do the job for them. But I had the impression that, especially in Los Angeles, we had a visit in the Twin Tower prison and correctional service unit with more than 4,000 inmates. A huge facility, and I had the impression that after having overcome bad times in the past with a lot of scandals, they are on a good way. It's not so easy to find the right balance and offering enough work and education. They do a lot of efforts to offer education to the inmates. This was impressive, I think. And they have, to my mind, compared to Austria, they have less work to be offered to the inmates, but they offer them a lot of education, and they have huge efforts referring to medical services. I mean, they have 50 psychiatrists, psychologists who are working there. 50. So in relation to the number of inmates, well, that's huge. That's huge. So I think we have to say that they are in a good way there, and it was interesting for us because they are on the way. The huge reform of the whole jail system, and we just started it. And the problem is, now we go into ethics again. Why do all the countries have problems with the jail system? That's because it's not popular to invest in the jail system. You won't get many votes if you say, okay, we want to invest in our jail system. It's, as I said, it's not popular. And that's why from time to time it needs a huge reform then, and that's the situation we are in Austria too.
I want to thank the minister, and I want to thank Dr. Kushner. We have a section outside, I hope, where you can talk to our Austrian guests personally. And again, I hope, we have a saying that if you do something 3 times, it becomes a tradition. So I hope we can soon have a tradition of an Austrian lecture here yearly on matters related to Austrian law, ethics, and social policy. Thank you all very much.
Thank you so much for having this opportunity, and I'm sure after the next year, Mr. Pinacek and me, we are on the movement.